So, give me a second. There we go. Okay, we'll move this over here. That's weird. It never shows. I mean, it never show up. I don't understand. Copy. And that one particular. I mean, it's just that one particular. Wrong one. What the fuck? Excuse me. This one. Mm-hmm. Oh. I can give it to. Can't get it to show. Can't even get it to show my display. Do a browser again. URL. There we go. That'll do it. All right. Okay. Got the browser up. Now, how do I interact with it? Interact. I want to scroll down, please. Why can't I scroll down? me scroll down. I don't get it. I don't know. Okay. So, you know, I noticed someone was having issues. Oh, I wanted to make a video or two. Listen to a person who had some bad stuff done to him, okay? And just listen to the story. Some serious violations have been taking place. From what I can understand from it, he spent roughly 48 days in jail with charges, but they were dismissed. They were never read their Miranda rights before taken to jail. The police officer that arrested her for assaulting a police officer, but after review of the body cams, that determined that was a lie. Which that in itself is a big issue. Firstly, if you're not read your Miranda rights, you're supposed to be let out of jail immediately, because that's an instant dismissal. I mean, every court does that. That's guaranteed. I mean, that is number one. You have to be read your Miranda rights. The judge refused to hear the case because of an existing warrant out of another state that was non-extraditable. As soon as that warrant was cleared up, the judge said, wow, acknowledged the errors, and then said, well, I'm going to just let you go and let the person out. I don't even know where to start with that, because, I mean, that's a Fourth Amendment violation. You know, that's protection against unreasonable search and seizure. You can't be detained for any amount of time without due process or hearing, and that's unconstitutional. Seems like the individual wasn't denied access to legal counsel, but was not properly able to contest the basis for detention. So that's a violation of your 5th and 14th Amendment because of due process. That long without a proper trial or denial of a jury trial is a denial, and a denial to confront the witnesses, the individuals making the claim of charges, for the charges, no proper arraignment, proper court hearings. That's a 6th Amendment violation. Not being read your Miranda rights may not invalidate the detention itself, but it's a big grounds for helping you in a suit. And, you know, just saying that the judge recognized the and was like, oh, well, we're just going to let you go and leave it be. He has a duty to ensure the constitutionality of detentions and felon to act. When someone's held without cause, can be seen as a dereliction of duty, or a deliberate indifference. You have a federal lawsuit at that point. Under 42 U.S.C. 1983, this law allows individuals to sue the state or city officials, including police staff, jail staff, and possibly judges and administrative rules for violating constitutional rights and not upholding your due process. You can sue for unlawful detention, failure to provide due process, emotional distress, and lost wages, and punitive damages, if you can prove bad faith or recklessness, which, by your story, of which you've said in the last 7 or 8 videos, you can. Judges, like I told you in general, have judicial immunity for decisions made in their official capacity, but not for administrative decisions or failing to act where there's no jurisdiction, or failing to act when your constitutional rights have been taken away. There has to be accountability, and there is accountability. File a complaint with the State Judicial Conduct Commission. Every state has a judicial oversight board, like I told you, and it's a commission on judicial performance. And you can file a formal complaint against a judge for refusing to hear the case, ignoring your personal constitutional rights, failing to investigate or act once he recognized the unconstitutional disregard. This misconduct is found, he could be reprimanded, suspended, removed from the bench. He could lose pay for it. So please, turn him in. Do the smart thing. I would, like I told you, review jail logs, court transcripts, warrant records, determine who's liable, and file a lawsuit within statute of limitations, which is usually 1 to 3 years, which you got plenty of time at this point. I would definitely contact the ACLU, the National Lawyers Guild. If legal action is slow, media attention can help push oversight bodies or city councils to act. You can go to the local news. They don't like it when you're in the media, which getting on TikTok and stuff, that's a good thing to help get noticed. The fact that the judge intentionally refused to hold a hearing on bond, knowing that you were being held improper, the judge may have violated their oath of office and enabled unlawful detention. Judges are not above the law. If a judge simply made a procedural error during court proceedings, then they're likely immune. But if they refuse to see someone who had no legal cause to be in jail, knowingly ignored the facts that would have freed a person, then they can be liable administratively or civilly, depending on the facts. So you do have a chance, even going after the judge for his negligence. You need to, like I said, don't try and do everything from memory. Write it all down. Document it, the dates, times, statements by court staff, judges, police. Get records of all of that, everything. Get the court and jail records, arrest report, the warrant data, judge's orders, the chain of command of how all that shit went down. You tell that court through the Freedom of Information Act and subpoenas that you want a copy of every document ever written down about you. File for discovery on all of the police officers and the judges. Make them ask a bunch of questions that pertains to you. Think about what kind of questions or comments would them judges or lawyers and stuff would have said to each other, because you can file for discovery to get them to answer them questions, and if you find negligence in their responses, then they can be held liable. They find any documents that they wrote down about you. File a misconduct complaint with the state's judicial oversight. File a complaint on the police officer. Request a public apology or a settlement from the city if they wish to avoid trial and lawsuits. And you definitely have a suit, and it's going to be a long, strenuous, time-consuming thing, but in the long run, that's what you're going to have to do, unfortunately, to get any remedy for the lack of proper performance, as they would say. And for now, good luck, and I'm going to make another video here in a second about public defenders and lawyers and their oath of office and their position and some of the options that you have based off of what your videos say you can do to remedy the situation that was handed to you. So give me a second to make another video because I'm ran out of time, but I do wish you well. Let me do some hashtagging here. Possible, but freedom challenge, baby. Freedom. So, if a public defender or court-appointed lawyer refuses to represent a client or fails to appear in court, dismisses serious due process concerns, engages in unethical behavior, there is options. That can amount to legal malpractice, ineffective assistance of counsel, misrepresentation, and possibly civil rights violations. This is your legal options and how to take action. And again, this video is for this young lady that had issues with the courts denying her due process and violations. Just from the videos on TikTok, pretty sad situation. I've seen a lot of pretty rough legal shit in my life. I've been around some bad people in my world, and I know when good people get shitted on, it sucks. So, you know, any way anyone can help, you know, with any form of direction or something, we should always do that. Ineffective assistance of counsel, guaranteed under the Sixth Amendment. A defense attorney must show up to court, investigate and prepare the case, communicate with the client, and advocate in good faith. If the lawyer ignores your concerns, laughs at you, or misses court, you have a grounds to challenge any outcomes in the case, even if the charges were dismissed. Okay. Legal malpractice is defenders have limited liability protections in some states if they willfully ignored a case, failed to appear in court, disrespected or humiliated a client, or committed any violated any ethical rules of conduct. They may be personally subjected to discipline or civil litigation. And again, a complaint needs to be filed with the bar on behalf of that individual, and the bar has to investigate to at least look good, you know, more or less. But if it's found that he's a piece of shit, he's a piece of shit. If their actions extend unlawful issues, which seems like it caused you to have extended unlawful detention, which that's a civil rights issue within itself, per the last video. And the only remedy is to go for a lawsuit. There's no getting out of that. Lawyers are held to rules of professional conduct, so you need to look them up for Oklahoma and see what Oklahoma says about how lawyers have to operate. Violations, look up neglect rule 1.3, failure to communicate rule 1.4. Let's see, disrespecting her client or acting without diligence is rule 8.4. Misconduct, you can file a formal ethics complaint with the state bar or an attorney disciplinary board. You know, you can, the state bar oversees lawyers in every state. You file a complaint, it could result in nothing, or they could lose their license. They can get reprimanded, forced to where they can't work for 6 months to a year, 2 years without work. It's gonna hurt, especially a lawyer who's got expensive taste. You could get orders of restitution, put against them. You can petition the expungement of your record. If the attorney's failures resulted in unlawful detention or harm to your record, and defiled your name, you can follow, when you're locked up, you need to learn habeas corpus, because habeas corpus is how you are let out of jail when you are illegally detained. You can get expungement of your record or sealing of the record. You can sue the public defender's office under 42 USC 1983. You can't generally sue them directly because they're not state actors, but you may be able to sue the county and public defender's office itself, which is a state actor. If they unknowingly assigned you an attorney who failed to supervise you, if the office repeatedly sends unqualified attorneys or turns a blind eye to ethical violations, they could easily be sued. But in your representation, you were flat out denied proper legal representation. You have a leg to stand on and some foundation, and anyone else in your position does. But it needs to be, if more of you would start a lawsuit on these things and go after your even though it's hard, I get, but if you take on the fight, remedy will come your way. Specifically, the lawyer, the public defender, you would look up civil rights violation, which is 42 USC 1983. Specifically, you want to seek for damages for emotional stress, lost wages, and reputation harm. Like I said, you want to request all public defender notes, emails, court motions, jail logs, case file from the court and clerk, write a timeline of events, missed hearings, court lawyer comments, ignore requests, any written communication with the lawyer. You want to file a complaint with the state board, consult a civil rights attorney. A lot of them offer free consultations these days. Consider filing a federal lawsuit for unlawful detention or violation of due process if you suffered actual damages, which you did. If there's public defamation of your character, that's actual damages. And in fact, let me find it. Court books. No, PDFs. Let's see. There you go. Okay. Numbers out of range. What does that mean? Ain't that something? I don't get it. Cool. PDF. Lifelong. Repair. What the dadgummit? Dang. I know dang well I can But anyway, um, I'm gonna draft up a little thing about habeas corpus and affidavits of truth, so that way you can use that to help clear your name of issues. And that will go through the court. It'll be certified through the court, put in the record, and even goes in the newspaper. But it will clear your name of any bad, and you can use it as part of your process moving forward for any suits that you may take or action that you may take against anyone in the future. All right. And this is how you can use an affidavit of truth to help yourself out. Okay. That's probably one of the biggest things is learning about affidavits. It's something, there's a lot to it, but an affidavit of truth is a sworn written declaration of facts. It's signed under penalty of perjury. It's notarized to make it legally binding, and it can be entered into court as evidence. It doesn't give you sovereign immunity like sovereign citizens think and make charges vanish, no. But it does create an official legal record of your truth that can be used in civil or family court and be filed in your legal case, support a claim of defamation or wrongful imprisonment and misconduct or defamation of character. Okay? You can use it to respond to false accusations by officials or family members. You can document due process violations or misconduct by lawyers, judges, and prosecutors. You can clarify your legal status or intent in court record. And you can support civil rights complaints, especially under 42 U.S.C. 1983. And you can use it to form a factual basis for a lawsuit, complaint, or motion. And since you said that you were going to file a federal complaint, affidavit of truth, because it guarantees it is legal. You can, such and such, a competent adult of sound mind and legal age, declare this affidavit as my sworn truth, made voluntarily and without coercion, for the purpose of preserving the record and correcting false statements against me. You can, you want to list all your factual assertions, okay, whoever it may be against. You can put, as an example, I was detained on blank on this date by this agency or individuals and was never read my Miranda rights. 2, I was held for blank amount of days without, with a few visits to a judge with refusal to hear my case due to a warrant from another state that was later proven to be dismissed. That wasn't, I was held for blank amount of days without being properly heard by a judge due to a warrant from a state that was later proven to be dismissed because it was non-extraditable. The public defender assigned to me, his name, failed to appear in court on this date, did this towards me, mocked me on this date when asked about due process. Family members, names, or certain relatives have made untrue statements to officials, damaging my reputation and leading to unjust scrutiny. This family member blank has made unjust comments to my clients and associates, which have tarnished my name and cost my business monetary value. The judge in my case admitted something wasn't right, but took no further action to correct the harm caused by my prolonged detention. All of that. You use it to assert the truth of record, and then at a bond, I affirm under penalty of perjury that the foregoing is true and correct to the best of my knowledge and belief. And you would bring that in front of a notary, and you would sign it under oath of perjury, and then the notary would sign as witness, and then it becomes certified. And you file it with the clerk of court as an affidavit of truth, as to have it entered into record, and any suit that you may have filed, which I thought you mentioned a federal filing, attach it as an exhibition exhibit, or just attach it as an affidavit, but you want to attach it to a motion for expungement or financial damages, whatever you're seeking as remedy for the performance of the court or whoever you're suing. Attach that affidavit to your motions and objections. If there's a comment made and you're like, no, that's not true, objection, Your Honor. My affidavit of truth right here, sworn under perjury, says different. Attach it to your state bar complaint against a lawyer. Attach it to the judicial conduct complaint of the judge that you want to file a complaint on. Attach it to a civil rights complaint, state and federal level. You keep a certified copy and then mail a copy to your local district attorney, your local city attorney or public defender's office, and you keep it for future court hearings, expungements, or lawsuits against them. it cannot erase your records itself, but you can attach it to a motion to get those records expunged and wiped away. It's not a magic bullet, but if used alongside formal complaints or motions and lawsuits, it can help you. Okay, it must be used alongside formal complaints, motions in your lawsuit. Okay, but you're certifying what is true, and the courts will use that as truth. And they have to use it as truth because that is truthful evidence that you have it had acknowledged and certified that it is true. You went and had it legally certified, making it legally true, which means anything that goes against what you put on that paper, if it's found to be untrue, you're fucked. So make sure that what you're saying is true, but in all rationale, you do seem very sincere, and I am very sorry for your situation. But if you need help writing a motion, I'm more than willing to help you learn how to write motions, affidavits, whatever I can help. Because I do want you to get proper remedy, which is I'd like to see you get your kid back. I know any mother that's sensible and loves their kids, they don't have their kid, it's hard on them. There's no doubt about that. My wife loves her two boys adorningly, so I could only imagine what you're feeling like. We've never lost our kids to no situation like that, but I can only imagine what you feel like not having your kid. So I do apologize, and I hope that I'm able to give you enough advice or help to get you moving forward, because you're at a point now where I do believe that you should get remedy from the courts for the things that have happened to you. Well, I am sad that it happened, but if you need anything specific looked up, let me know and I'll look for that stuff. Or if you need a rough draft of, say, an affidavit you can modify to fit your needs, or a motion, a specific type of motion, you can give me general principle of what it needs to be about, and I can write up a formal rough draft where you can modify certain elements of it to fit your specific requirement, so that way you don't have to indulge any information, and you can keep yourself private. So make you a Proton, look up Proton Mail, make you a Proton email. It keeps you private, and I can send any help to that, and you don't have to worry about being exposed. Okay? Good luck. And if you need any help, please ask. I'll do what I can. Okay. Okay, let me see. Something opened up, huh? Okay. So, I'm gonna get rid of this. Okay. I just wanted to help that person. So, sorry, I made a couple videos. But, get right into it. Found this really, really cool article here. It's called acquiescence. Okay, it's similar to the doctrines of the estoppel and practical location. It is an equitable doctrine that will fix the location of common boundary in a location that may differ from the location where the surveyor would place the common boundary based on the rules of construction. The doctrine of acquiescence is known in some jurisdiction as a consentable boundary. Some states have equated it to a boundary by implied agreement. The motion for a court recognizing a boundary different from record is to let boundaries that appear to have been settled to be settled. A person that sleeps on their rights should not be allowed to demand with passion what they have so long ignored with indifference. Okay? The doctrine of acquiescence generally requires three conditions to exist. First, the record boundary must be vague for unknown. The purpose for this element is to prevent persons from usurping the legal requirement that parties alter the location of their record boundaries by written instrument. By requiring the boundaries be vague or unknown, the legal fiction is created that the parties in interest have not altered the location of their deed boundary. Rather, the parties in interest have fixed a definite location for boundaries described in their respective deeds. This fiction survives even though a surveyor would place the boundary with some confidence in a different location than where the boundary location has been historically recognized. A second condition requires one party act by fixing the boundary in a location by definite monumentation or occupation that appears and is accepted by marking the boundary. The boundary so fixed by the one party cannot be based on fraud or deceit. In other words, the party in placing the monuments or barriers must have reasonably believed the objects are placed on the common boundary. The third condition requires that the non-acting party recognize the boundaries, the barriers, or monuments as marking the boundary. Recognition is sufficient if the individual does not contest the location. The fourth and final condition is that the three conditions exist for some length of time that a reasonable person would not have been expected to object or act had they disagreed. A long length of time is not crucial if the location of the record boundary is otherwise vague or difficult to locate, and the location of the monuments or barriers is reasonable to the location of the record boundary. The following situation may give rise to a boundary by acquiescence. Just the way they word this stuff, huh? They are very slip of the tongue. I'm not a snake, I can't double fung it, But wow, just the way they word it. And right here, Cudd is a professor in surveying engineering technology program at the University of Maine. He is also a consultant on boundary disputes, alternate dispute resolution, land development, and real property law and access law. Rob is a professor in the surveying engineering program at Michigan Technological University. He is a professional surveyor and holds a MS, Master's in Spatial Information Science and Engineering from University of Maine, Orano, and is currently working on a doctorate in civil engineering. Bill and Jane lived next to each other in an old subdivision, but does his best to locate the common boundary he shares with Jane in order to build a rock wall. He takes measurements and sets the stakes, eventually building the rock wall along a line between the stakes. Jane watches Bill take measurements to locate the boundary and observes Bill construct the wall. For many years thereafter, Jane and Bill respect the wall as marking a common boundary. 12 years later, Jane needs a survey of a property in order to build a garage. And performing the survey for Jane, the surveyor gathers considerable site and record information. Most of the original monuments have disappeared. The surveyor prorates the distances between found monuments that are located several hundred feet away with the following results in the diagram right here. Okay, so in the above situation, the court would be reluctant to adopt the boundary established by the prorated distances over the distance of the stone wall that has been accepted as the boundary for some length of time. The wall is located within reason to the record boundary. It has been accepted as the boundary for over 12 years. The upheaval and disruption in the neighborhood that would result with adopting lines that differ from the long-standing occupation flies in the face of equity. It is reasonable for a surveyor to adopt an occupation line as a boundary where the record boundary location is vague, difficult to fix, or a reasonable location of the record boundary is on or near the occupation line. Justice Cooley remarked on this very situation in the late 19th century using these words: occupation, especially if long continued, affords very satisfactory evidence of the original boundary where no other attainable, and the surveyor should inquire when it originated, how and why the lines were then located as they were, and whether a claim of title has always accompanied the possession, and give all the facts due force as evidence. Unfortunately, it is known that surveyors sometimes, in supposed obedience to the state statute, disregard all evidences of occupation and claim of title, and expunge whole neighborhoods into quarrels of litigation by assuming to establish corners at points with which the previous occupation cannot harmonize. It is often the case when one or more corners are found to be extinct, all parties concerned have acquiesced in lines which were traced by the guidance of some other corner or landmark, which may or may not have been trustworthy. But to bring these lines into discredit when the people concerned do not question them, not only breeds trouble in the neighborhood, but it must often subject the surveyor himself to annoyance and perhaps discredit, since in a legal controversy, the law as well as common sense must declare that a supposed boundary long acquiesced in and is better evidence of where the real line should be than any survey made after the original monuments have disappeared. Thomas M. Cooley, Chief Justice, Supreme Court of Michigan, 1864 to 1885, and the judicial functions of surveyors. Basically, what you can process from that, if you don't say something in a formidable, in a proper amount of time, you afford all your rights. If you want something to happen and you don't digress it and say, well, in a proper amount of time, you lose out. Point blank period. There's nothing you can do about it. You chose not to do anything about it. You chose to keep your mouth shut. Okay? And that is your fault. And that's how the law looks at it. Okay? The law doesn't care. You chose not to listen. You chose to not care. So the law says you too bad. Okay, you're the one who chose. Order. Move up. That's right. Order. Move up. That's right. Oh, yeah. Oh, yeah. Yeah. I'm a Southern boy, big boy. Ain't nobody racist there. Brighter than bees, boy. Anyway, right there, you have to go against something that you see that you don't appreciate, that you think is injustice. You have to say something right then and there, or within a lengthy time. Just like crimes, if something's done wrong to you, you have a specific length of time to make a suit against it. You know, there's a statute of limitations. Some crimes have statutes of limitations. Plenty of civil suits. You know, if you have an issue with your neighbor, you know, this way or that way, each cause can have a different length of time. The statute of limitations. So I want you to remember that. This right here is telling you have a specific statute of limitations, or you have acquiesced to your right. I'm gonna bring this right here, and I gotta go to the bathroom. I'll be right back. Okay. So, you know, when sovereign citizens talk about, your driver's license, okay, you have been given them and complied consent for ages. You've acquiesced already your rights. And this might just be about boundary law, but it doesn't just persist to boundary law. That's what people need to understand about a lot of things is this isn't persistent to just boundary law. This right here isn't just boundary law. Okay. When this case, you acquiesced to your property because you let it stand for 12 years. You're beyond the statute of limitations for argument. She should have had the property surveyed right then and there and cleared up that settlement. But because she allowed him to establish the stone wall and not complain about it, she acquiesced the statute of limitations to allowing him to create a new common boundary for their property. So what did he gain? A whole foot? 6 inches? He didn't gain much, but the boundary wall's a little bit in her yard, but it's nothing for her to be arguing about. But I just wanted you to see, this is an old case about acquiescence, okay? Acquiescence is something you should look into in Black's Law Dictionary. This right here, great book. It's a legal maxim. And a maximum is a established principle proposition, a principle of law universally accepted or admitted as being just and consent within reason. Maxims and law are somewhat like I've never been able to properly pronounce that word. Axioms in geometry. They are principles and authorities and axioms. There you go. That's what it is. Okay. Been a little while, but I figured it out. But I should have went to the store. I should have not to. Make me run. Yes. Oh, yes. I'm gonna have to make me want to do it. Anyway, maxioms and law are somewhat like axioms in geometry. They are principles and authorities and part of the general customs or common law of the land. And they are of the same strength as acts of parliament when judges have determined what is a maxim, which belongs to the judges and not the jury. Terms du lay, doctrine, and studies. Maxims of the law are holden for law, and all of the cases that may be applied to them shall be taken for granted. The application of the maxim to a case before the court is generally the only difficulty. The true method of making the application is to ascertain how the maxim arose and to consider whether the case is to which it applied is the same character or whether it is an exception to an apparently general rule. The alterations of any of the maxims and of the common law are dangerous. The following are some of the most important maxims. There should be no departure from common observance or usage. No one is bound to do what is impossible, and that one is a very important one. And I talked about that one in another video. From the words of the law, there must be no departure, but we've seen plenty of that. There ain't no doubt about that. The absence of him who is employed in the service of the state ought not to be burdensome to him nor others. I'm mad I forgot to get the store. Son of a bumper. An absolute unqualified sentence or proposition needs no expositioner. A lot of these I have to still look up, but they're very interesting. You can use them to your advantage. If you can prove the maxim in court, then that is all you need. That is the burden that you have, is you must prove without a shadow of a doubt the maxim exists. And if you can prove that a maxium was broken, you're good. Just like no one ought to accuse himself unless before God. That one, you don't have to answer any questions that, and like I talked about in my last video, you don't, which I talked about this maxim. You don't have to answer any question, even in court, that violates the Fifth Amendment. You don't have to self-incriminate. Just like an accessory follows the nature of his principles. They have the crime accessory to the fact, or accessory to a crime. This here, an accessory follows the nature of his principle. If you were accessory to a crime, it's because you were a follower, not a leader. Right here, the accessory does not lead, but follows its principle. You know, that's kind of the thing, and that's how laws for people that are accessory to a crime come about. I mean, you're helping them. You're an accessory to the problem. You're an accessory to the fact. So, there's legal maxioms like just like those two. There's a reason why you're going to fucking jail when you help someone kill somebody, or when you help someone rob a damn bank. An action is not given to him who has received no damages. Actio non deter non dam beneficio. If you are brought before a court without charges, no corpus delicti, no injury, then there can be no relief. There can be no case. A state of claim for which, it's a state of cause of action for which relief cannot be granted. You motion to dismiss, for a lot of things, your motion to dismiss is for failure to state a cause of action for which relief can be granted. And in some cases, you would like to collect your costs and fees. And that legal maxim applies specifically to that. And action is not given to him who has received no damages. Which means if you have not received any damage, then you do not deserve any remedy in the court. A personal action dies with the person. This must be understood of an action for tort only. I do believe that means that if a person has committed an action against you and they die, it stops there. In regards to a tort, he ought not to be heard who advances a proposition contrary to the rules of law. That applies to sovereign citizens. And that right there specifically says, he who makes proposition that goes against the rules of law shouldn't be heard in a court of law. If you're a sovereign citizen, that applies directly to you. Ain't no getting around it. Blatantly clear, some sovereign citizens clearly want to remove some rules of law and some forms of regulation that are good and must be applied in order to have some levels of freedom. There are people who have levels of fuckery that need to quit fuckerying around you. The plaintiff must follow the form of the thing in dispute, which means if a plaintiff is to take you to court, he must follow the rules of the court he's in. Therefore, he must follow the process. And if he does not follow proper procedurals, then actions and claims can be taken against him for impropriety. for being improper and causing damages against the defendant that were unjust and unnecessary. If when the plaintiff cannot prove his case, the defendant is absolved. Right there, if you can prove without a shadow of a doubt that the plaintiff has no case, then the defendant should be free. An act of God does no injury. That is, no one is responsible for inevitable accidents. So, if you're hurt by an act of God, there is no one that you can sue. Okay? State, person, nobody. An act that has an act already begun, the completion of which depends upon the will of the parties, may be recalled. But if it depends on the consent of the third person or of a contingency, it cannot be recalled. Depends on the consent of the third person or of a contingency, it cannot. Okay, so if people start to commit an act and then say, ooh, and stop, then it shall be done. But if they come to a voting session and it requires a contingency, then that act cannot be stopped. That's what that means. Okay? If you do something because you're held against your will or you're forced against your will, like you kill someone against your will, it is not your act. So this legal maxim, actius me invideo factius non est meus actius, is for you. You know, you use that legal maxim to your advantage. You know, always remember, take maximum advantage of everything, especially your own damn weaknesses. If you're not good at something, take advantage of it. Better it, stronger it. An act does not make a person guilty unless the intention was also guilty. You can make a mistake, and if it wasn't intentional, it was just you being stupid, it doesn't make you guilty. It just means that you're a fucking retard, and you need to think before you act. That's what it means. Acts required by law to be done admit of no qualification. That I will have to learn, because I don't know what the hell that one means. I haven't seen that one yet. And I just found this one. Let's see. The act of the law does no one an injury. How's that going to help you? Let's see. Where is that? Let's Google that real quick. Okay. The act of the law does injury to no one. It's a Latin legal maxim used across common law and civil law system. It reflects a foundational principle in legal reasoning when the law itself mandates or causes an act of no legal injury, injustice, or harm is recognized because the action is deemed lawful by nature. Literally meaning, an act of law harms no one. If a legal outcome is the necessary consequence of a valid law, it cannot be challenged as unjust even if it causes inconvenience, loss, or hardship to a person. This maxim supports upholding actions that flow from the rule of law, legal certainty, state authority, reinforcing that lawfully exercised power does not equate to a tort or actionable harm. Balance of interest, recognizing individual loss doesn't always imply legal injury. In property law, when a person loses property due to eminent domain or forfeiture under valid statutory authority, axius legius applies. The house seized under a lawful foreclosure isn't wrongful, even if it causes hardship. In contracts, the law may void or enforce a contract under statutory provisions, and the resulting impact is not an injury per se. A contract is voided because it violates public policy. The harmed party cannot claim the law injured them. In civil procedure, if a judge is lawfully entered by default or due to procedural issues, even if one party suffers a disadvantage, it is not considered a wrongful act. In family law, statutory actions like child support garnishments are not legally injurious if carried out by proper authority, even if they affect income. In criminal law, a person held in jail under proper legal procedure, even if later found innocent, may not automatically claim the imprisonment was injury by the state unless a violation of due process or malice prosecution occurred. And regards to the beginning of this video, right there, it applies. This legal maxim, an act of law harms no one, does not apply because you did have a violation of due process and malice prosecution. Case laws. Tinsley v. Treat, 2005, 205 U.S. 20, 1907. The court noted that if the result is dictated by law, there is no injury, even though inconvenience or hardship arises. Basically, you can lose your fucking job and there ain't nothing you can do as long as they're within the bounds of law. An eviction based on code violation laws was upheld since the law mandated the action. Actus legis applied despite economic harm. That was Aiken v. City of Philadelphia, 2008. So basically, he had a bunch of code violation laws that he violated, and he was evicted, and he tried to apply actus legis. He tried to say the laws harmed him and caused him hardship, but actus legis applied despite that economic hardship because he was violating the fucking law in the process. Criticism and limitations of power and imbalance. It can be seen as favoring state or institutional actions even when morality is questionable. Just because something is legal doesn't mean it's just and lawful. Critics argue that over-reliance on this maxim can blind courts to real-world harm. Modern use, courts often balance actus legis with constitutional rights and due process protections. If a legal authority acts outside its scope or in bad faith, the maxim does not protect them. Example, if a judge jails someone without jurisdiction or a public defender refuses to show up, the injury is no longer a lawful consequence, it's a due process violation, and actus legis does not apply, and therefore they can be sued. Strategic use in a legal argument. To use this maxim to defend against claims, I acted under a lawful court order, use counter maxioms to challenge a ruling that causes harm under the guise of law. Let's look up, let's see. And specifically for this young lady, where there's a right, there's a remedy, and let justice be done through the heavens falls. And like I told you, you got to pray to God. You got to pray to him and allow him to take the wheel and walk you forward. He'll guide you through every bit of this. Extreme laws is extreme injustice. These can be used to argue when the law is applied too rigidly or without discretion and harms of spirit justice. Actus legis nemini facit injuriam. The law does not injure when the acts are lawful. State actions, judgments, and legal outcomes that cause loss are procedurally correct. But are procedurally correct? There's nothing you can do about it. Doesn't apply to unlawful, excessive, or unconstitutional actions. And claims of due process violations, civil rights violations, and abuse of power are often challenged. Actus legis, and you would have to file some civil rights claims, some motions and affidavits, for sure. So that's a very important legal maxim, actus legis nemini facit injuriam. let's see, the antecedent bears relation to what follows next, unless it destroys the meaning of the sentence. Huh. Okay, well that's a very interesting one. The judges do not answer the questions of fact. The jury do not answer questions of law. Basically, that means the judge can't answer questions for the jury, and the jury cannot answer questions for the judge. I'm pretty sure that's what that means. But I want to Google the antecedent. Okay, so the antecedent bears relation to what follows next unless it destroys the meaning of the sentence. The antecedent, what comes first, is presumed to be connected to what comes after, especially in grammar or legal reasoning. However, if applying that relationship causes contradiction, confusion, or destroys clarity, the antecedent cannot logically be considered connected to what follows. Example, when John saw Mike, he smiled. Who smiled? He could refer to John or Mike. The antecedent, John, appears first, so it's assumed that he refers to John. But if that destroys the meaning, contradicts other facts, the assumption is revised. So, in legal interpretation, antecedents and statutes, contradicts, or affidavits must be logically linked to what follows. But if the link creates absurdity, ambiguity, or injustice, then the court rejects the connection. Example, no vehicles may enter the park that are gas-powered and painted red. Does that or gas-powered and painted red apply to all vehicles or only a subset? If interpreting that "are" to mean all vehicles causes illogical or unjust restriction, the relationship is narrowed. Maxioms that align, words preceding may be explained by what follows, but also a word is known by the company it keeps, meaning context matters. If the relationship breaks context, the interpretation must shift. And that's why I tell you in my videos, what's most important is how you properly word things. Don't be ashamed to use legal AI to convert your crudely worded sentences into legal perfection. Take advantage of everything, especially your own weakness. And your weakness is you suck at wording shit legally. In fact, you suck like hell. I don't give a fuck how good you are. Unless you're extremely well dialed in legal terminology, you're not good at it. So use something that has all of legal knowledge to help you educate your legal phrasings. I'm not good at it. I ain't no shame in my game. I'm not good at it, but I'm trying to learn. And while I'm trying to learn, I'm trying to share. I want y'all to see what I see what I find. That's what it's all about. Spreading knowledge. If you see something and you want to expand on it and teach more, please stop in, leave a comment, help. Don't be afraid to expand the knowledge of an individual around you. It's important, very important. Just like judges do not answer questions of facts, the jury do not answer questions of the law. This principle defines division of responsibilities between judge and jury during a trial, just like I assumed. And see right there, that's what the last maxiom says. Read the sentence and make a determination. These involve legal interpretation. What does a statute mean? Is this evidence admissible? What are legal standards? What legal standards apply? The jury cannot handle those because that's interpretation of law, and the judges are responsible for deciding questions of law, and they instruct the jury accordingly how to interpret the law. Did the defendant actually steal? Was the witness credible? What happened to the scene? Juries decide questions of fact based on evidence and testimony presented at a trial. This division exists. It prevents abuse of power by keeping legal authority, judges, and fact-finding power, juries, separate. Preserves the right to jury by a trial by ensuring that ordinary people, not state officials, determine guilt or liability. Enhances fairness and accountability in court decisions. But let's stop there and think about that for a minute. Okay, that division of power is constitutional, right? You have the right to jury trial at all costs. But yet, you can go to traffic court or parking ticket court, code enforcement court, and you don't get a fucking trial. You get a trial, you get a bench trial, the judge is guaranteed to determine your guilt or liability. And state officials. The Constitution rests that if anything comes in that you have to pay more than $20 in civil, or you can be locked up, you have a right to a jury trial. All criminal cases have a right to jury trial. So if you're not afforded constitutional protections, then how is it a legally valid court? I mean, answer that. How can we continue to allow this courts to be legally valid when they're not upholding the Constitution by affording me the right to a jury trial if I get pulled over for fucking speeding, 10 over, 50 over, or whatever? That's not fairness and accountability in court decisions, now is it? It's not. But here we are, we have these legal maxims that are in play here, but yet you're not afforded them rights in certain courts, which are quasi-judicial courts. And they don't give a shit about your freedoms or your rights. But by all accounts, these legal maxims are how courts and judges and lawyers are supposed to understand things. This is how you're supposed to interpret the law. And yet, judges sit on benches day in and day out, willy-wagging, the woolly-walking, and disregarding due process. Like it's stink on shit. No big deal. Just whatever. It's due process. Fuck them. Let's go. No big deal. They don't give a damn. They don't give a shit that your rights are being violated. I was listening to a guy today, and he was talking about how people think cops are your friend and they're there to help you. They're not. They're there to execute summons against you through the courts. The courts file charges against you, issue summons and complaints, and fuck, you're stuck, because now the executive branch is coming after you, and we're going to put you in jail. Alright? So, no smoke, but a toke, right on down and down. Okay. But, we have these safeguards and protections in place, but we're not afforded those safeguards and protections in every court, every day. In fact, we're not afforded a whole lot in these courts every day. And we get shitted on and lose our rights because we don't say nothing. Real world examples, in criminal cases, the judge rules that a confession is admissible in evidence, but the jury decides whether the confession proves guilt. In a civil case, a judge decides when contract law applies. The jury decides whether a party breached that contract. But you can go to traffic court, and the judge determines if you're fucked or fucked. And 9 times out of 10, if you go to traffic court, you're fucked. If you commit a traffic infraction, you're going to pay for it, unless you pay for a lawyer to get you out of it. In which now you're spending money, and that's what it comes down to is money. 100%. If you spend money, you're free. Only the lucky or people with good backgrounds win in court. You know, you get that lucky war veteran who wins because they just don't want to fuck with him because he was a hero to the country, and he's in a very liberal ass state where he can get away with shit. But in conservative states, they don't give a fuck. They're gonna rape you backwards, upside down, and inside out with Vaseline. Like bench trials and traffic cases. You know, the judge handles both law and fact. The judge may dismiss the case on legal grounds before it goes to jury. A jury's decision may be overturned if they misapply the law or act unreasonable. So even then, a judge can disregard what the jury says if he thinks that they were wrong. In reality, you know, basic summary, the judge is there to interpret and apply the law, and the jury decides the facts based on evidence, and its purpose is to maintain fairness, impartiality, and balance in trial procedure. But the fact of the matter is it fucking doesn't. I don't give a flying fuck. Okay, yeah. But they don't care. You know, so for the most part, this legal maxim is broken. Let's see here. What we can find. Summary of Federal Rules of Criminal Procedure 56. If the judge decides the case without trial, if no genuine issue of material facts exists intended for clear cases, often misused to strip jury trial, even in debatable fact-based cases. Motions to dismiss under 12b6. A claim can be dismissed before discovery by the judge, assuming facts as true, but saying they don't meet legal thresholds. This can result in fact-based dismissals without jury input. Administrative courts and agencies, Social Security Administration, Workers' Comp Boards, immigration courts, traffic courts, they're all quasi-judicial administrative agencies. They make fact-finding about a case, issue binding rulings, and often lack a jury altogether. These bodies act like courts, but aren't Article III courts, and often lack due process rights at all, including lack of right to a jury trial. After a jury conviction, judges often make additional factual determinations, aggravating circumstances, and use those findings to enhance sentences, federal sentencing guidelines. This raises due process issues, how a judge determined facts that increase punishment beyond a jury found. This was challenged in Apprendi v. New Jersey in 2000 and Blakely v. Washington in 2004, where the Supreme Court ruled any fact that increases the penalty must be found by a jury beyond a reasonable doubt. Yet some courts still creatively interpret this with bench trials and plea agreements without a jury. Due to overloaded dockets, defendants are often pressured into waiving jury trials in exchange for a plea deal, except in bench trials where judges decide both fact and law. While voluntary on paper, this undermines jury fact-finding as a cornerstone of due process, especially when the police system becomes coercive. Judges issuing direct verdicts, or JNOV, judgment notwithstanding the verdict. These allow judges to overrule jury decisions when they find the jury was unreasonable. It's useful in extreme cases, but misused, it nullifies jury sovereignty and fact-finding. Qualified immunity and absolute immunity. In civil rights suits, 42 U.S.C. 1983, courts use doctrines like qualified immunity for police and officials, absolute immunity for judges and prosecutors. These allow judges to dismiss claims without letting juries examine facts like excessive force used, due process violations. This blocks access to juries and insulates state actors, reinforcing quasi-judicial imbalance. That's your only remedies and resistance is to demand jury trials in all cases where liberty, property is at stake. Challenge judicial fact-finding in appellate courts. Push for legislative reforms to limit summary judgments and enhance access to jury trials. File constitutional challenges, 6th and 7th Amendments, when quasi-judicial systems deny due process, and expose misuse of immunity or administrative authority via civil rights litigation and public pressure. You would have to, use like legal AI to come up with your motions and things, but it's removed by the verification of the deed. A hidden ambiguity of the words is supplied by the verification. For whatever ambiguity arises concerning the deed itself is removed by the verification of the deed. Look that up, because that's interesting. Let's see what they say on breakdown. Let's see. Latent ambiguity. An ambiguity not apparent on the face of a document, but revealed when applying the language to external facts or situations. For example, a deed grants land to John Smith, but there are two people by that name in the area. The verification refers to some kind of external confirmation, such as testimony, oath of affidavit, other document evidence, action taken by the parties. Okay. This removes or clarifies the ambiguity by confirming the true intent or meaning behind the words. This ties to ambiguity arising concerning the deed itself is removed. This ties into the legal concept that intent overrides unclear wording, especially when supported by verified evidence. The phrase emphasizes that ambiguities that are not obvious in the text can be resolved with proper verification, such as witness testimony or supporting documents. Application in law and contracts. If a contract contains vague or conflicting terms, courts allow verified eccentric evidence to clarify what the parties actually intended. In wills and deeds, if two similar names or descriptions could apply to multiple people or properties, verification like maps, affidavits, or testimonies clear up ambiguity. In judicial or administrative processes, affidavits often supply documents to remove doubt about their meaning and application. Due process implications in criminal or civil law, ambiguous evidence or actions can be clarified through verified witness statements, surveillance, chain of custody logs to support fairness. Okay, so you can use it when there's charges against you to force clarification. In the legal practice, in modern use, it applies if you're dealing with a misunderstood affidavit or filing, poorly worded legal instrument, accusations or claims based on unclear documentation. You can invoke this principle to say the ambiguity is not fatal to the claim or defense, as it is a latent ambiguity clarified by verified context or corroboration. For example, if you had a really piss poor filled out citation or police report that lists the wrong address, but surveillance photo and affidavit prove where the event actually happened, you can invoke it. You can argue through the document, though the document contains ambiguity, verification through video and sworn statements removes any confusion regarding the incident's actual location, consistent with the principle that verification secures latent ambiguity. So, and equal is the law of laws. The proof lies upon him who affirms, not on him who denies. This one is a great one because it is yours and the court. The proof lies upon him who affirms, not on him who denies. It means the plaintiff, all burden is on him to affirm the claim against you. And even in traffic court, though you're guilty until proven innocent, you have to fight for your freedom. If you can prove that the executive officer, which is the claimant, the plaintiff, cannot prove burden of proof, or you can keep the ball in his court where he can't get it out of his court by playing chess with words. He can't show burden of proof. You don't have to answer any of the questions. You can answer with questions that put burden of proof back on the individual challenging you. An alternate petition is not to be heard. That applies to, just like double jeopardy. You can put that in the same construct. Just because one petition for charges against you goes to state doesn't mean a second is allowed to. You can't do it twice. Once you've won, you won. Points of law are not law. That is a great one, because that is a good one, because you can make interpretations that is more of a legal issue or principle that a judge must interpret or apply in a case. It may include interpretation of a statute, determining the constitutionality of an action, deciding whether a specific legal rule applies to a case. Like, for example, does the Fourth Amendment apply to warrantless GPS tracking? I would like to fucking think so. How are they getting warrantless anything? That's what the Fourth Amendment is. protection against anything without a warrant. They need to have a warrant to do anything against you. But you've agreed to that license by signing your last name, and well, statute of limitations, you agreed to it. That's implied consent. So I imagine that the Fourth Amendment doesn't apply, and they can easily construe that. Definition of law is law, in contrast, refers to codified statutes, constitutional provisions, or common law precedents or regulations enacted by legislators or recognized through legal traditions. Example, the Fourth Amendment of the U.S. Constitution, or 18 U.S.C. 922G. And we're going to look that up. So, 18 U.S.C. Pasto El Cemento makes it unlawful for certain categories of individuals to ship, transport, possess, or receive firearms or ammunition. This includes individuals who have been convicted of a crime punishable by imprisonment for more than 1 year, fugitives from justice, and unlawful user of or addicted to controlled substances, have been adjudicated as mentally defective or have been committed to a mental institution, or are subject to domestic violence restraining orders. This section is part of the Gun Control Act and aims to prevent firearms from falling into the hands of individuals deemed a risk to public safety. So, a question is raised in a case about how the law should be interpreted or applied. The law, the point of law, is, so the distinctions here is the point of law is a question raised in a case about how the law should be interpreted or applied. And law is the actual legal text, rule, or doctrine. Point of law arises during litigation. Law exists independently of any one case. Points of law may vary depending on jurisdictional rulings. Law is intended to be fixed, objective, and known. Point of law is interpreted by judges. Law created by legislators or derived from precedents. Okay? Due process and legal clarity. Courts must not treat evolving opinions about law, points of law, as the law itself without clear constitutional or statutory basis. Doing so can lead to arbitrary rulings, judicial overreach, and violations of due process. Precedents versus statutory law. A judge might decide a point of law based on precedent, but precedent isn't binding law unless it aligns with higher authority like Supreme Court rulings or statute. So the danger here is when judges treat their interpretation, a point of law, as the law, they blur the boundary between the role of interpreter and lawmaker. Juries decide questions of fact while judges decide questions of law. But if the judge's point of law conflicts with actual law or is ungrounded, it may violate the Separation of Powers Act. Marbury versus Madison in 1803. Chief Justice John Marshall famously said, "It is empathetically the providence and duty of the judicial department to say what the law is." This recognizes that courts interpret the law, not create it. So when a court decides a point of law, it's issuing an opinion, not making the law. Consequences of confusing the two is judicial activism. Courts go beyond interpretation and create policies. Citizens may be judged by opinions instead of real written law, and that's an erosion of your rights. You can have unlawful imprisonment, detention based on judicial interpretation rather than statute can violate fundamental liberties. Let's click on this. If you're challenging a court's ruling that misapplies to a principle, the court's conclusion represents a point of law, not the law itself. The actual statute does not support such an interpretation, and to treat it as binding is a violation of due process. Or, a point of law being an interpretation must remain subordinate to the actual letter of law, lest judicial opinion override legislative will. So, may remain subordinate to the actual letter of the law, less judicial opinion overrides legislative will. Interesting. Man. See, this is why legal maxims are important and why you should use Google and legal AI to understand things. You can learn a lot. Let's see. An argument arising from a division is most powerful in law. Okay. So, let's see here. Reflects an ancient legal maximum grounded in logical interpretation and the use of distinctions to clarify or reveal contradictions in law. In the following paragraph below, let's explore this deeply, including its origin, application, and impact on law reasoning. And I put it up on the screen, but I don't know why it's not coming up, so that's why I'm just reading everything. I keep trying to add the browser, and it just won't add. The phrase is often tied to an argument from division is most forceful in law. It teaches that dividing a general statement or rule into its distinctive parts, a process called logical division, can impose inconsistencies, exceptions, or overbroad application of a law. In simpler terms, when you break a law, statute, or argument into its parts, the resulting distinctions can form the strongest legal argument. So, suppose the statute says no vehicles may be operated in the park, including cars, motorcycles, and electric scooters. Division argument might show vehicles as a category includes many things, but a wheelchair or baby stroller is also a vehicle in some sense. Should they be banned too? This division exposes the implied intent and limits of the law. Example, the First Amendment protects freedom of speech, religion, press, and assembly, etc. Dividing each component can highlight how certain laws infringe on one right, but not other. Strengthen an argument by showing how liberty stands independently and not merely as a part of a collective freedom. I want to look straight into it. It's just, I don't know. It's off. Division strengthens legal arguments. Clarifies intent, helps judges interpret what legislators meant in passing a law. It reveals overreach, shows when laws are applied too broadly or inconsistently. It differentiates terms that are wrongfully lumped together. And if a rule logically applies to one part but not the others, it may be invalid in whole or in part. In legal briefs and oral arguments, argument from division is used to dismantle vague or overly broad statutes, challenge unlawful prosecution by separating lawful conduct from accused behavior, and apply scrutiny to different parts of a statute or regulation. In a modern example, imagine a city ordinance says all sound amplification in public is prohibited. You divide that. Does this include a protester with a bullhorn? How about a street performer with a Bluetooth speaker, or a person using a hearing aid? This division sharpens the argument that the law, as written, is too vague or overbroad and may violate the First Amendment. To legally apply, you can use, by dividing the statute's terms, we see that it applies inconsistently and criminalizes protected conduct. This supports the conclusion that the law was facially overbroad and unconstitutional. Or, an argument from division compels the court to recognize the distinction treatment required under the law, strengthening our claim of selective enforcement. Interesting. So, can use that to break down the statute or ordinance. Start by identifying the exact code or statement under which you were cited. Suppose you were cited under a statute that says no vehicle shall be parked in a no parking zone at any time. To apply the maximum, divide the statement. What qualifies as a vehicle? What is meant by no parking zone? And at any time, is at any time absolute, or are there exceptions listed elsewhere? You might find that the best definition of vehicle excludes electric scooters or bicycles. The no parking zone was not properly signed or designated, and certain vehicles, government delivery, are exempt during certain hours. And if those distinctions apply to your situation, the law may not apply to you, or was implied incorrectly. Say you got a ticket. You need to always use division within procedural requirements, and many traffic citations rely on procedural steps being followed. Notice, signage, officer authority, and this goes for criminal arrest, citations, complaints, civil notices, civil lawsuits. You could argue if the law says signs must be clearly visible, but you divide that to mean day and night visibility and show the sign wasn't lit at night, you may argue improper notice. Some states divide traffic offenses into civil infractions and criminal violations. And use this division, you can challenge improper punishment for civil infraction, threatened by jail time. Even though it's a civil infraction, you're threatened by jail. Misuse of burden of proof, criminal standard applied to a civil infraction. So you can use that argument. You can apply this legal maximum. An argument rising from a division is most powerful in law, and you can apply that because it's misuse of burden of proof. When you have a civil infraction while you're in a criminal court. So criminal standards are applied to a civil infraction, but you're not afforded criminal due process. So legal division strengthens your due process argument if you're going to use that in a traffic citation matter. In some citations, failure to stop, unsafe turn, intent matters. If the statute prohibits knowingly failing to yield, you can divide accidental conduct, slippery road, unclear signs, deliberate violation. You may show your actions lack the required intent, so the charge doesn't apply. Challenge the application of law. When an officer cites generic codes, if you divide what they claim happened, what the law actually prohibits, you can argue the officer applied the wrong code or misunderstood the law. If cited for obstructing traffic, but your car was parked legally during a loading period, you divide parking versus stopping versus standing under the city ordinance. This shows your action didn't match the infraction. If you was going to do, say, a written motion, you might say something along the lines of, say you got a, it just depends on the situation, but we'll just use the example that this has. An argument, Your Honor, an argument from division reveals that the statute in question, when broken into its constituent parts, does not encompass the conduct I was cited for. The term vehicle under the ordinance excludes non-motorized scooters, and the sign indicating no parking zone was obstructed after dark. Thus, applying the citation against me constitutes overbroad and improper interpretation of the law. It breaks down the law into parts and identifies exemptions. It separates and defines each term, operate, stop. It contrasts facts and what the law actually prohibits. Divide required process versus what was followed, and divide what was observed versus what's required for the citation. Very important information, and I am glad that I decided to look that up. An argument drawn from what is inconvenient is good in law because that law will not permit any inconvenience. Okay, well, an argument from the greater to the lesser is of no force negatively. Conversely, it is. Okay, well, we're definitely going to read that one. So, let's look that up. Let's see what we get. Go to this page. Positive use allowed. If something is permitted in a lesser case, then it's also permitted in a greater case. If something is prohibited in the greater case, you cannot assume it is prohibited in the lesser case. Interesting. If I have permission to carry a knife, the lesser, I have permission to carry a sword, the greater. From greater to less. If I'm prohibited from carrying a sword, it does not mean I am prohibited from carrying a knife. Greater versus lesser. It protects rights by preventing assumptions that prohibitions automatically extend downward unless explicitly stated by law. The maxim is used in statutory interpretation, constitutional law, criminal law, and administrative and regulatory matters. It ensures that governments or courts don't overextend prohibitions beyond what the law clearly states. And traffic law. Imagine a statute says, no person shall drive a commercial vehicle over 10,000 pounds through the city center. Invalid negative inference. Since large commercial trucks are prohibited, small delivery vans must be too. This would be invalid under the maximum because the prohibition on the greater, large trucks, does not automatically apply to the lesser vans unless the law explicitly says so. The Constitution grants, let's say the Constitution grants the right to free speech shall not be infringed, which it does. Valid inference from lesser to greater. If the government cannot ban mild criticism, it also cannot ban intense political speech because protecting a lesser right implies the protection of the greater. But if the government cannot ban a newspaper, it must be able to ban a private citizen's blog. That would be invalid because the greater prohibition doesn't justify a lesser one unless the law explicitly states it. But the law cannot violate a constitutional right, which we know they do all the time. Application in fighting abuse of power. If a judge or official argues, we banned a higher level of conduct, so this lower level is obviously included. You can use that maxim to respond. A ban on the greater offense cannot be presumed to prohibit the lesser. The law must specifically include it, or the presumption is void. Use this maxim when someone is stretching the means of law to apply to more broadly. You are being punished or restricted without a clear legal basis, or you're defending a lesser action that was not explicitly prohibited. So in summary, don't allow others to use greater to lesser logic to restrict your right. Use the lesser to greater logic to expand your freedoms or justify your actions when not expressly prohibited. This maxim is a check against arbitrary or excessive interpretation of the law. prima facie evidence is cited for speeding. For example, understand that exceeding that limit is presumed unsafe, but you may present evidence to counter this presumption. So, prima facie evidence is definitely something that you should learn about, because basically it means at face value. Basically, they can presume that you were speeding, and unless you can prove their presumption wrong, you're guilty, automatic. You must rebuttal the presumption with evidence showing that your speed was reasonable and prudent under the circumstances. Say states like most states that use prima facie, which rule basically reasonable and prudent, they base their traffic laws on the principle that speed must be reasonable and prudent considering road conditions, visibility, traffic density, weather, and time of day. So if you was to fight against prima facie, you would have to demonstrate that despite exceeding the posted speed, your actions were safe and controlled under actual conditions. You can gather dash cam or surveillance footage, shows light traffic, clear visibility, dry roads, controlled vehicle operation, disproves officer claims of erratic or dangerous behavior. If you have a passenger or bystander confirming that your driving was smooth and safe. Certified weather data from NOAA or similar proving ideal driving conditions. Road construction or layout may warrant temporary higher speeds. If you have onboard telematics or GPS logs, you may be able to show gradual acceleration, no abrupt braking, controlled lane use. If everyone was driving at or above your speed, you may argue flow of traffic required you to speed to avoid impeding or becoming a hazard. Always request discovery and challenge officer judgment. Use discovery to obtain radar, LiDAR calibration records, officer training certifications, audio, video from the stop, challenge any inconsistency in how the speed was measured, officers' claims of what was unsafe, lack of traffic, clear weather. So always cross-examine. If say on the citation he just puts down speeding and it gives you the general code for speeding, but there's 15 subsections. Challenge him on that. Ask him. Say, cite the law and the 7 sub-laws, 7 sub-performances required for this law to be, and explain to me exactly which one created your determination. And if you can't, generally they do so many tickets a day, they're not going to be able to remember all of it because they don't write down everything, and especially if they don't write down anything. You can support your argument with legal doctrines like prima facie rebuttal. A presumption is not evidence and disappears when rebutted. That was State versus Lawful, UK. That was a Utah case law. De minimis non curax. The law does not concern itself with trifles. 3 to 5 mile an hour over the speed limit on a clear highway is punitive. You can write a persuasive statement for the court. Yes, I was driving 68 and 55, but traffic was light, visibility was perfect, road conditions were dry, and I was matching the flow. I maintained full control of my vehicle and posed no risk. Here's footage and weather data to support that. You can use legal maxims if the judge is open to legal theory. An act is not unlawful if done with care, under necessity, or safety. What is not dangerous under the circumstances is not danger in law. Um, don't flat out say everyone else is speeding too. Don't admit fault without providing context. And do not show up to court unprepared. Bring documentation. If you're facing a traffic citation, definitely study every aspect of procedure, the citation, the statute, prepare rebuttals, prepare motions, all of that. Find any inconsistencies, file for discovery. Don't just sit on your butt. If you don't ask for it, you ain't gonna get it. If you want to play hardball, file the motions the day of court. That'd be really annoying, but it'll show them that you're not there to be their friend, but you're there to be a nuance and hopefully be dismissed. They don't want to deal with you because they see that you're not going to be easy to deal with in court. You're going to be quite inconvenient for them and cost them time and money. And time and money is not what they want to waste, by no means. And right here, this legal maxim right here, an argument drawn from similar case or analogy avails in court. That means you can use case laws, court cases from other states or federal to aid in your argument. Use that to your advantage. Let's see. I'm gonna look this up too. Let's see here. Let's see what we get popping up. Let's see. Foundational principle of legal reasoning. Legal arguments carry the greatest persuasive and binding weight when supported by authoritative sources. The phrases were derived from classical legal maxims rooted in Roman law and later adopted in English common law. An argument from authority is the strongest in law. Argumentum ab auctoritate est fortius is lege. So, in law, authority refers to binding or highly persuasive source, such as statutory law, federal or state statutes. It has binding weight. Case law, presidents from higher courts, binding and persuasive. Constitutions, U.S. Constitution and state constitutions are supreme authority. Regulations, agency rules like DOT, are binding. Legal maxims, long-established principles of law, are persuasive. Scholarly treatises, writings by legal scholars or jurists, are persuasive, such as Blackstone, which he was in the 1600s, but he was a very smart legal mind. And he has his own book, Blackstone's Law Dictionary. In legal disputes, courts prioritize predictability, consistency, and precedent. An argument from authority anchors your claim in established law, limits discretion and bias from judges, and overcomes opposing claims based on its subjective or novel reasoning. For example, arguing my speeding was reasonable is weak. Arguing Utah courts in State v. Doe held that exceeding speed limits during emergency transport was not unlawful is authoritative and much stronger. If you were truly speeding out of necessity, that's authoritative because you have the legal right to necessity. You can't just be out frolicking fucking. There has to be a purpose. no doubt about it. When building legal arguments, whether in traffic law, civil litigation, or criminal defense, you can strengthen your case by citing statutes under Utah Code, blah, blah, blah. A driver may exceed the limit if necessary to avoid a collision under 41-6A-605. Interesting. Right out of there. Necessity. If necessity to avoid a collision is required. In State v. Barlow, the court ruled that technical errors and Miranda warnings do not void a valid confession. For example, like my friend, acquaintance that I've been watching the videos and plan to help any way I can when asked, detaining a person for 48 days without arraignment or due process violates the Sixth Amendment right to speedy trial. Invoking legal maxims. No one ought to be twice troubled for one and the same cause. Double jeopardy. You can't be charged twice. Argument. Distinctions between argument and assertion. Strong argument from authority includes citation of a law or case, explanation of its application, or a logical link to your situation. A mere assertion, like it's not fair or that's unconstitutional without authority, is weak and easily dismissed. You must have lots of court cases and legal standings on your foundation. Like I told that young lady, foundation is important. You must have it. You better bring case laws with you, and you better read those case laws so you can understand how you determine your foundation. In legal advocacy, your best tool is to root your argument in authority. Not only does it show preparedness and legal literacy, it forces the judge and opposing party to reconcile your case with established law. If you're preparing for a hearing, responding to a citation, or drafting a motion, look for relevant cases and statutes to strengthen your argument. If you have a violation of due process, look up, search Justia for, or have AI help you find cases. Ask it, show me 25 federal, state, and local cases around the country, the United States, that deal with due process violations. Specifically, this is what happened to me, and this is the violations that happened. What cases can I use to help my argument when I go for a lawsuit or such and such? It's imperative that everything is worded correctly, and that's what I've learned so far. Is legal wordings are much stronger and more intelligent in standing than non-legal phrasing. If you use layman language, you're not going to get anywhere in the courts. In fact, they're going to make you think that you're stupid. But if you use AI to help you convert your layman language to legal language, it seems like they look at you a little differently, and they need more time to ponder what you say to them. Very interesting. Natural equity or good faith do not allow us to demand twice the payment of the same thing. I think that one speaks for itself. If you help someone in good faith, you can't demand payment from them twice. You give a person an apple, or you buy an apple from a person, and something happens, and it wasn't intentional, and you made a trade in good faith, you can't ask for it twice. It is the part of a good judge to enlarge his jurisdiction, that his remedial authority. I'm going to look that up. I'll scroll through the next page. Because that is an interesting legal maxim. It is the duty of a good judge to remove the cause of litigation. The good of a defendant arises from a perfect case, his harm from some defect. According to justice and right, and prefers equity to strict law. Necessary good is not good beyond the bounds of necessity. A fortuitous event is not to be foreseen. No person is held bound to honor. Given to oblivion is left to the disposal of common. It is the part of a good judge. You know what? Let me go. 1 second. Real good. So, the maxim is the part of a good judge to enlarge his jurisdiction, that his remedial authority is a historical and interpretive legal principle that speaks to the duty of judges to expand, not limit, their power to administer justice and provide remedies, especially in situations where the law is silent, ambiguous, or insufficient to address an injury. A good judge should not take a narrow or rigid view of their power. They must interpret the law in ways that maximize the court's ability to offer justice and remedies, particularly when a strict interpretation would deny relief. The aim is not to expand for control, but to ensure the court fulfills its purpose as a forum for justice. This maxim arises from equity jurisprudence and common law traditions where courts were often tasked with interpreting involving statutes, creating remedies where statute relief was not provided, or filling legal gaps where principles of fairness of equity. The chancellors of English equity courts especially followed this maxim when formal legal rules failed to address novel injustices. Judges may grant injunctive relief or equitable remedies when statute doesn't specify, and read implied rights of action into statutes when necessary to protect constitutional rights, and allow writs of habeas corpus, mandamus, or prohibition to enforce due process. Courts often lean on interpretive canons that support this maxim, such as, it is better for a thing to have effect than to be void, and laws should not be interpreted to permit injustice unless clearly intended. Hmm. This maxim does not mean judges can invent law arbitrarily, because that would violate separation of powers, okay? Um, Courts can extend their jurisdiction where they have no constitutional or statutory basis. Instead, what it does mean is existing lawful jurisdictions, a judge should do everything possible to correct wrongs and provide fair remedies to you. Okay? For example, my friend being 48 days without proper arraignment, or being read Miranda rights and being denied a court case because of a previous warrant, that's not a good judge. A good judge under that maxim, legal maxim, would not ignore the case due to technical jurisdictional barrier. That wouldn't have been an issue. That was intentional. And would exercise remedial discretion to order release, issue sanctions, or remediate redress, recommend redress. However, in her case, the judge did not. And the judge is a rat piece of shit, in my opinion, but what I know. The judge, from my understanding in the videos, is well known in that part of town as a no good individual. And I guess that particular part of Oklahoma is known for bad cops. I guess Wyoming and Idaho is the same. There we go. You know, a lot of people have bad things done to them, but they don't do anything about it. Me, myself included. But I feel like after a while, you get tired, and you get beat down so much, and you can't take it no more. And then you want to try and do something. You know, there's so many legal maxioms, so many ways to say this, so many ways to say that. But the fact of the matter is, if the court wants you guilty, you're guilty. There's nothing you can do about it. You know, like here, strategically, you can use it in a legal argument to invoke the encouragement of a judge to act affirmatively when due process violations occurred. Government misconduct is evident, and remedies are technically outside of strict statutory prescriptions. Your Honor, the courts have long held that it is the duty of a good judge to enlarge his jurisdiction, that is, his remedial authority. I ask this court to view its power not narrowly, but in light of its duty to correct injustice and uphold constitutional principles. You know, you use it to call the judge to fairness. It encourages judges to embrace their full power to do justice, especially when lives or liberties are at stake. And unfortunately, there's always going to be injustices. But I implore you to be a nuisance and be a problem for them. If they want to be a problem for us, then waste their fucking time in court. Irritate the shit out of them. I swear by it. Irritate them. Irritate them. Piss them off that you take them to court. Piss them off that you have the gall to fucking say something. Piss them off. Fuck them. They need to wake up and realize that the people of this country are tired. I saw today on Twitter. Hold on, let's see. Tweety twit. Fuck out of here. Let's see. Where was it? Let's see. Breaking the golden age of Nasera Jacera. We're in the largest revolution in the history of mankind. A small percentage of the population of the earth have known this was coming for a long time. However, the bulk of humanity do not read history. And this comes from the real JFK Jr., John F. Kennedy Jr. Twitter page. However, the bulk of humanity do not read history, don't pay any attention to it, and are therefore either oblivious to the changes around them or just in denial. What you're about to read is real. Much of it has already been implemented. Just no rebuild to the world, not quite yet. The time is coming very soon. Here's an explanation of Nasera Jacera in great detail, the keystone, if you will, of the changes coming to every country on earth this year. It is the end of poverty, the end of debt, and the beginning of a new golden age. The announcement of Jacera will affect the entire world, amounting to a total of 206 sovereign nations. A new financial system is a part of Jacera law. Now I'm reading this on a phone on Twitter. Zeroes out all credit, mortgage, and other bank debt due to illegal banking and government activities. This is the Federal Reserve's worst nightmare. A jubilee for forgiveness of debt. Abolishes income tax, which I know Trump is trying to do. And I appreciate that. It abolishes the IRS. Employees of the IRS will be transferred into the U.S. Treasury National Sales Tax. It will create a 15% flat tax on non-essential new items, only sales tax revenue for the government. In other words, old homes or items, used items, can't be taxed. Interesting. Increases benefits to senior citizens, returns constitutional law to courts in legal matters, reinstates the original title of nobility amendment. I would appreciate that because I have very strong nobility lineage. I come from a lot of knights and princesses and kings and dukes and barons. My grandfathers helped found this country, and they've been here for a long, long time. It establishes new presidential and congressional elections within 120 days of Nasera's announcement. The interim government will cancel all national emergencies and return us back to constitutional law. Monitors elections and prevents illegal election activities of special interest groups. It creates a new U.S. Treasury rainbow currency backed by gold, silver, and platinum, precious metals, including the bankruptcy of the United States initiated by Franklin Roosevelt in 1933. It forbids the sale of American birth certificates records as chattel property bonds by the U.S. Department of Transportation. Wait a minute here. I got questions. Let's look this up. Let's see. does the sell birth certificates certificate records as chattel property bonds what is a chattel property? That is a claim commonly found in sovereign citizens' conspiracy theories and has no basis in fact, law, or recognized financial systems. Chattel property refers to movable personal property, cars, furniture, livestock, tools, jewelry. It is a legal term dating back to common law and means personal possessions that can be bought or sold. Conspiracy theorists claim the government creates a corporation or straw man version of every person at birth. A bond is issued based on your birth certificate. The government allegedly trades or sells this bond on stock exchanges or uses it as collateral. Therefore, your birth certificate supposedly makes you chattel property or a slave under maritime law. Currently, no government agency, including the DOT, Treasury, or Department of Commerce, creates a financial bond based on certificates, or at least there is no evidentiary proof. Your birth certificate is a vital record, not a financial instrument. It is issued by state vital record officials, not the federal government. There is no secret account, bond, or trust tied to your birth certificate. Courts, banks, and financial institutions do not recognize these theories. They are rejected regularly as frivolous and without merit. DOT gets lumped into these theories because sovereign citizens idolize misuse of UCC terms like chattel bonds and commerce. The DOT regulates transportation, which conspiracy theorists associate with admiralty law or maritime jurisdiction. But this has nothing to do with being street property. So, if you ask any questions, it comes up as pseudo-legal gibberish and legally unfounded. So that means there must be something hidden somewhere that proves this right. But until then, the United States v. Beneby, 7th Circuit Tort, 2011, courts are not required to entertain sovereign citizen claims that have no legal basis. Brant D. Wash, Union Bank, 2009, rejected the idea of birth certificate bonds as nonsense. That lawyer, see if we can find it. Technically, any document presented in court can be rejected as hearsay, which is defined as an out-of-court statement offered to prove the truth of the matter asserted. But there are exceptions to hearsay rules, especially for public records like birth certificates. Under records of vital statistics, birth, death, marriages are admissible if they are kept under law by public authority. Federal Rules of Evidence 801, hearsay is a statement that the declarant does not make while testifying at the current trial or hearing, and a party offers in evidence to prove the truth of the matter asserted. Hearsay is inadmissible unless an exception applies. It is often used in traffic citation scenarios, in traffic citation courts, to seek contestant of evidence without directly challenging the facts. It rarely succeeds on its own, but there are legal valid ways to raise hearsay objections against traffic citations. You're cited for speeding. The citation is based on the officer's observation and radar room. At trial, the prosecutor introduces the citation as a police report without the officer present. Now, you may challenge that document as inadmissible since the statement is made out of court. You cannot cross-examine the officer who made it, and it's being introduced to prove you were speeding. The officer must testify. If the officer doesn't appear and only the evidence is the citation or written statement, you can object. Hearsay. I have the right to confront and cross-examine witnesses against me in the Sixth Amendment. Therefore, you can motion for dismissal because you don't have won't be able to cross-examine, and that's violation of due process. Melendez-Diaz versus Massachusetts in 2009, the Supreme Court held that lab results used in place of live witnesses violates the defendant's confrontation rights. While this case dealt with drug tests, the same logic applies to any testimonial evidence, like radar or LiDAR reading interpreted by someone not present in court. Radar, LiDAR, speed cameras, and red light cameras generate data. If a technician or an officer who set up or analyzed the data doesn't testify, you may argue this machine-generated report is introduced to prove a fact without live testimony or foundation. Objection to the hearsay rules and confrontation rights. Some treat machine data as non-hearsay since machines don't speak, but the interpretation of logging of that data by humans is hearsay unless the witness is present. You can challenge whether the citation or report is properly authenticated under Federal Rules of Evidence 901. The prosecution has not laid proper foundation to show that this document is what they claim it is, especially relevant if there's no live witness to attest to the process, it's unsigned, unclear, or ambiguous record. And in my case, that's what I put on my motion, which it wasn't denied, but it wasn't approved, so when I go to court, we'll find out. Because my citation, there was nothing written on it. It was so basic. It had the wrong address. It had used a P.O. box that my wife uses temporary instead of my home address, and which I haven't received any documents from him anyway at any address, so I guess that doesn't matter. But he didn't put nothing. I don't know how he obtained his information, nothing. So I'm going to try and get that excluded from testimony. I'm a motion to have it, if my dismissal is denied, I'm a motion to have his testimony very bland, because if he couldn't give that information in the beginning to solidify his case, then he shouldn't be allowed a late discovery. That's bullcrap. For realistic application in courts, be aware, most traffic courts are informal and operate very relaxed evidentiary rules, often not requiring but 50% evidence. Some judges may allow hearsay over objection unless you are full evidentiary trial, not a bench hearing. Still, you can use these arguments to lay groundwork for an appeal if the judge ignores them. Demand the officer's presence. When you get to court, ask for discovery for all evidence, radar logs, dash cam notes. If only a document is introduced, and there's no information on it, that can just be hearsay, because there's lack of authentication, and it's, if the cop doesn't show, that's a violation of confrontation clause. Quit using admiralty law and names in all caps, it's not gonna get you nowhere. Claims that statutes don't apply to you, arguments that you're not driving or traveling. I've always argued that they're just gonna hurt you in court and make you look dumb. you know, okay. 901A says to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. In traffic cases, specifically, the prosecution must prove that a citation accurately reflects an observed offense. It was issued by a qualified, credible witness, a cop. The method used to observe the offense was valid and properly applied. LiDAR, radar, pacing, whatever, visual estimation. The defendant, me or you, was actually involved. With 901, if your citation has incorrect information or it's missing information, is unsigned or incorrectly filled out, doesn't clarify you or your vehicle, has inconsistent or ambiguous details, you can object to lack of authentication. You can motion for dismissal for lack of authentication under FAR 901. The citation lacks sufficient information to be admitted as evidence that you committed a violation,